This is the second in a series of short videos that will clarify information about the Family Homes on Reserves and Matrimonial Interests or Rights Act, or the Act. We will look at the first main part of the Act, Enactment of First Nation laws, the First Nations Lawmaking Mechanism.
The Family Homes on Reserves and Matrimonial Interests or Rights Act contains provisions for First Nations to enact their own matrimonial real property law, should they choose to do so. Section 7 came into effect on December 16, 2013, and provides for the enactment of MRP laws respecting the use, occupation, and possession of family homes on its reserves that applied during the conjugal relationship, on the breakdown of the relationship, or on the death of a spouse or common law partner, respecting the use, occupation, and possession of family homes on its reserves. The laws can also address the division of the value of any interests or rights held by spouses or common law partners in or to structures and lands on its reserve. The Act does not state how the laws should specifically be designed. It allows for each First Nation to shape them according to their community's particular needs, values, and customs. Once it's enacted, the First Nation law cannot be disallowed, altered, or cancelled by the minister or any government official. It is the First Nation government and its members that determine the content of the law. There are several stipulations in the Act relating to First Nation laws that are not optional. Section 7 states that there must be a process for amending and repealing the First Nation MRP law. Section 8 explains the requirements for obtaining community approval. The law must also conform to both the Canadian Charter of Rights and Freedoms and the Canadian Human Rights Act. When a First Nation makes the decision to develop its own MRP law, it is required to notify the Attorney General of any province or provinces in which it has reserves. This advises the provincial justice departments that a new First Nation law may be coming into effect. The Provisional Federal Rules, the second main part of the Act, came into effect in December 2014 with some exceptions. If your First Nation is a signatory to the Framework Agreement on First Nations Land Management, you may have a different coming into force date for the provisional rules. These rules apply to most First Nations that have not yet enacted their own MRP law. If your First Nation has enacted its own MRP law, is a signatory to the Framework Agreement on First Nations Land Management, or has retained reserve land under a self-government agreement, the provisional rules may not apply to your First Nation. It is important for individuals to determine the applicability of these provisional rules based upon the land management regime in place in your First Nation. At any time that a community completes the process of developing and ratifying its own law, the provisional rules no longer apply. The Centre of Excellence for Matrimonial Real Property has developed a comprehensive toolkit to help First Nations with the MRP lawmaking and ratification process.
To access the MRP Toolkit and for further information, please visit our website at COEMRP.ca. This video is for information only and should not be relied upon as legal advice. Individuals should always obtain legal advice from a lawyer familiar with their specific circumstances and the provisions of this Act.